Hello. Hello. How is everybody doing tonight? I hope you're well. Let me pull up we're rushing around. Just a second. There we go. Hello, Chris and Tricia, Grandma Sherry. Good to see you here. Been missing you. Chaotic, Professor Pug, Ivy Rose, Mrs. Depp, Taffy, Digger Dave. Hi, guys. So Beholder and Jack. Hello, Lynn. Reach into my soul. Good to see you guys. What I did basically with Greeno, and if you go back farther to when I was doing the podcast, just the audio, I just go through the court records, just somewhere where it's like and I'm really going to try hard to only have a brief discussion at the end where I insert my opinion. And what do they say about opinions? They're like butts. Everybody's got one. It is what it is. But a court record is basically the close to, you can get of just giving the information as it's relayed in the documents, which I did request, just the same as anybody can. It's your right to do that under public access laws in Indiana. So that's what we're going to be doing tonight. Some of it I'm not going to read all of each. I got like 20. I don't know. I think it was like 27 or 28 PDFs. So it's a lot. And a lot of them are, like we don't need to read every single thing on there, but I want to try to do it as close to what I've done in the past. I think it's helpful to show, your proof and not when you can. And we have this, and it also will cut down on speculation. And, they stand for themselves, and that's, what I plan to do. So we also have some things that were just added today. So obviously I haven't sent her for that, but Aspen, Connor with It's a Crime and Shame, and Amy, Chaotic Beauty, had sent me some of those. So I am going to read those as well tonight. I have not read them yet, so we'll be reading them and learning together, but I'm going to save those for the end. And I'm going to do this in chronological order from October 28th all the way until December 1st today. So without further ado, here we go. Okay, so State of Indiana, County of Carroll versus Richard M. Allen, and the cause number is 8, which is the number for Carroll County. It's C01, which is Circuit Court 1. The year is 22, so we have the 08C01, 22 is this year, and then 10 stands for October. And then MR is murder. And the 00001 is for, this is the first murder charge filed in 2002 in Carroll County. The other case number for when Judge Diner recused himself is 22 SSJ 00369. And that's Indiana Supreme Court Special Judge. And it was the 396th appointment of a special judge in 2022 in Indiana. That will help you in, it's all standard. So once you find out the county number, which so you can, when you're searching my case, you want to, if you look under the prosecutor, for instance, say you want to search a prosecutor in Tippecanoe. Tippecanoe, if you look at the top and you search that prosecutor, it's going to pop up all different criminal offenses that have taken place from the soonest to, later. Tons and tons of them will pop up. Fractions, everything. And you will notice that they all have a number in common. So that makes just like understanding, when you see what we've seen on Greenos, when we've gone through those, is where MR is, you've seen felony, you've seen D1, F, different initials go in there. So criminal misdemeanor, CM, just something helpful for when you are looking at cause numbers. I don't know. I love little information like that. I'm a super big nerd. Okay, so this case was filed on October 28th of 2022. The defendant is Richard M. Allen. His attorneys are Bradley Rosie, and he is the lead. He's retained on contract. He is a public defender. Attorney Andrew Baldwin is retained on contract, and he is a public defender as well. State of Indiana is the plaintiff in this case. Attorney Nicholas McClelland, Carroll County prosecutor. So each prosecutor, in each county. So like I've been hearing things about why hasn't Prosecutor McClelland done anything about Keg and Klein. Well, that's not his county. So he would not be prosecuting over that case. That they just have the information as far as Kagan goes. He has not been connected to Delphi in any way other than I find it, like looking back and knowing how trial court things go, releasing a interview, a transcript is highly reckless, and it's done nothing but hurt the double homicide investigation for Abigail Williams and Liberty German. The charges that he is facing is count 1, and this was on February 13th of 2017. The statute is 35-42-1-1 parentheses 2. So in Indiana, that is Indiana Code 35-42-1-1. It's murder. Section 1. So you've got the first number 1, a person who, second number 1, knowingly or intentionally kills another human being and kills another human being while committing or attempting to commit kidnapping. Because we already know that that's what the court documents are going to show here in a minute, so I'm not going to read that whole paragraph. The degree is simply murder. There is no higher offense in Indiana than to be charged with murder. Any type of death penalty case will be a motion or petition to the court to then decide whether they are going to seek the death penalty. And that is a different phase of the jury trial, if it so leads to that. So count 2, again, February 13, 2017. Same exact code. So he is charged with 2 counts of murder and kidnapping in the state of Indiana. And the chronological case summary. So on October 28th of 2022, this was when they had basically not a secret, but it was not disclosed before, and then the probable cause affidavit and charging documents were sealed at the time of October 28th. So the case was opened as a new filing. That just means it was created. The petition was filed. I'm assuming that would be the arrest, but I do not know. Then the order was issued. So the courts or the judge made an order. Information was filed, and that's in there twice. So I'm assuming that is the charging information for Richard Allen, the alleged murderer of Abigail Williams and Liberty German in Delphi, Indiana on February 13th of 2017. The probable cause affidavit was filed on the 28th as well. An order was issued upon that, and that is by the court, so the judge. An order on the initial hearing was also ordered by the judge, and another order was issued by the judge. Then we move to November 2nd of 2022. We see another order issued, and it is an order acknowledging a public hearing. Okay. So we see all of the same things. When they do this, obviously it's just cutting out a bunch of zeros. It's still the exact same case number, cause number, interchangeable word. And it has the seal on there. And again, you'll see my my marking here. What I can't remember what those are called. Watermark. That is just simply because well, it's my choice, and I decided to do that, and I've done it on all of my stuff, and it's always said case 6. So I collect these and I request them from the Carroll County clerks or wherever else mainly gets emails because I don't like to leave my house very often. But yeah, so you, under Indiana law, anyone can have public access information. So a public hearing will be conducted pursuant to Indiana Code 514.35.5 and any rule of court of access to court records. So that's what I was just talking about. And that is Rule 6. Indiana Code, you can literally go on Google, you type in iga.in.gov, and you can literally go through and teach yourself all about Indiana Code. It's just that simple. Some of it can be hard to understand, but I feel like the more time you spend in it, the more time you understand it. So it just, you learn as you go is the best way to do that kind of thing. Oh, wrong one. So basically, this is talking about the hearing that they had on the 22nd. Parties or members of the general public will be permitted to testify and submit written briefs subject to reasonable time constraints imposed by the court. A decision to seal all or part of the public record must be based on findings of fact and conclusions of law showing that the remedial benefits be gained by effectuating the public policy of the state declared in Section 1 of this chapter are outweighed by proof by a preponderance of the evidence by the person seeking the sealing of record that, number 1, a public interest will be secured by sealing the record. Dissemination of the information contained in the record will create a serious and imminent danger to that interest. Any prejudicial effect created by dissemination of the information cannot be avoided by any reasonable method other than the sealing the record. There is a substantial probability that sealing the record will be effective in protecting the public interest against the perceived danger, and it is reasonably necessary for the record to remain sealed for a period of time. Sealed records shall be unsealed at the earliest possible time after the circumstances necessitating the sealing of the records no longer exists. So ordered on November 2nd of 2022. Remember, again, we're going through a chronological order. And this is signed by the judge at that time. And the next chronological entries we have is a hearing was scheduled. So hearing schedule activity for November 2nd of 2022 at 9 a.m. A hearing was scheduled activity for January 13th of 2023 at 9 a.m. And this was to be the pretrial hearing or omnibus. Those words seem to be interchangeable. And it was canceled and rescheduled for January 17th of 2023 at 10 a.m. Now, there is now rescheduled again a new hearing that we will find out about later, and it is on January 13th, 2023 at 10 a.m., but we'll read that together later. Another hearing scheduled activity is the jury trial. This is just standard. They put this on the books because it is a part of criminal law and procedure. Does that mean that the jury trial is definitely going to be on March? I would highly doubt it. I highly doubt it will be on March 20th through the 24th of 2023 at 9 a.m. for each day. On November 3rd of 2022, a motion is filed. This is a request by the sheriff of Carroll County, Indiana, to transfer the inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping. The undersigned states, I am the duly elected sheriff of Carroll County, Indiana. The aforementioned defendant, Richard M. Matthew Allen, has been incarcerated since October 26th of 2022, initially at the Carroll County Jail, and then transferred to the White County Jail at my request as sheriff of Carroll County, Indiana. The defendant has been charged in a high-profile cause, creating potential safety and security concerns because of the extensive coverage of various media platforms, both mainstream and social, throughout this state, the United States, and the world. In that the defendant has been charged in said high-profile cause, it is felt by the undersigned potential safety and security concerns exist involving not only the defendant, but also both jail facilities in Carroll and White counties within the state of Indiana. Because of the aforementioned reasons, as sheriff of Carroll County, Indiana, I cannot provide the services, attention, or supervision necessary to protect or meet the defendant's needs or to ensure, protect, and guarantee the safety or security of the defendant's staff or facilities. Pursuant to Indiana Code 3533.11.1, I respectfully request from the court an order approving the directing the transfer of the defendant to the custody of the Indiana Department of Corrections. Said agency has agreed to accept custody of the defendant for safekeeping. As provided by Indiana Code 3533.11.5, I will be responsible for transporting or for coordinating transport arrangements with the Indiana Department of Corrections, the defendant to and from their respective facility for further court proceedings. I certify to the best of my knowledge that the information set forth herein is true and correct, and this is signed by Sheriff Tobe Leazenby on November 2nd of 2022. Everything, as you can see so far, the Indiana code for each citation and section they have named. We saw that in the last document that I showed. Everything is above reproach at this point. There is nothing that they have done that is going to jeopardize the case. That is an opinion that is backed up by the citation of Indiana code. Okay, so then the judge makes his order on the request by the sheriff. And it is, it didn't need to be this long, but I think that there were other things going on, and you can tell that the judge is overwhelmed, and he is trying to do the best for this case that he possibly can. And I think that he did a fantastic job considering the circumstances around what all has transpired in that short amount of time in a county that you have to remember. You pull up my case, type in the attorney box, and you type in Nicholas McClelland and Shane Evans. And then just look at those two and pull up all of the cases that this judge and Judge Troy Hawkins, and I think there's one more occasionally, and that they are responsible for proceeding over. So they have all of this, and now they have a media frenzy. Maybe a strong word, but when you are getting incessant calls, it is overwhelming for a county of this size. I don't care. I don't think it speaks to their preparedness. I think it is what it is. And the county is made up of board members. So if you have a problem with it, instead of taking it to the courts and the poor clerk, I think that you should take that to the board that is presides over Carroll County. And I'm sure that you could even find the person that is in charge of the financial well-being of the county and send your complaints there. In not just this case, but in any case. The court ordered on November 2nd of 2022, Tobe Leslie, sheriff of Carroll County, filed a request by the sheriff of Carroll County to transport inmate from the Carroll County Jail to the custody of the Indiana Department of Corrections for safekeeping. The court, being duly advised, finds that defendant is an inmate awaiting trial and is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. This finding is not predicated on any acts or alleged acts of the defendant since arrest, rather a toxic and harmful insistence on public information about defendant and this case. In general, this court has 30 days to rule on any motion that is filed by a party in any case. See Indiana Trial Rule 53(1). So again, citing why whomever was calling incessantly was wrong for telling them that he was going to face litigation for this next part here. But concurrent to the actual case naturally occurring, this judicial officer keeps getting direct requests for non-parties for public information, claiming that this officer has 7 days or 1 day when hand delivered to respond to the request or face litigation. So that was actually laughable if whoever, did that. And while this officer is responsible for the entirety of the circuit court docket, it attempts to ignore the maelstrom of interest from the public. It is known that YouTube already hosts content regarding family members of this judicial office, including photos. Whoever did that is a piece of shit. The public's bloodlust for information before it exists is extremely dangerous. All public servants administering this action do not feel safe and are not protected. I would feel the exact same way. Put yourself in his shoes. The Carroll County Sheriff has limited resources to conduct its base operation, let alone any duties mandated by our Supreme Court. Again, take that to the board. All defendants in all actions are presumed innocent. All public information will be available the second it exists. None of the family members of public servants are part of this action. All of the public servants are simply people doing their jobs. Most of the public servants are woefully underpaid. Most of the public interest consists of people attempting to raise their status or profit financially. When the public peddles misinformation with reckless abandon, we are all not safe. I really like that line. As far as the public's desire to learn about access to court records, that educational effort cannot be by this officer educating each individual ad hoc whenever they choose to seek public information. These inquiries are inherently disruptive to the operations of the court, as they are wholly outside the operations of the court. All true. As a branch of the Supreme Court, any request for public information about this action should be directed to whomever is the public information coordinator for the courts in general. If there is not such a position, our state may need one. Defendant indicated at the initial hearing an intention to hire private counsel. Defendant is reminded that he must retain counsel within 20 days. So all of that about all the things that you hear, just all the supposition about, they're doing something wrong. Again, no, they're not. He wanted to hire originally on the 28th, he had a hearing and he wanted to hire his own private counsel. And the defendant is reminded at this point that he has 20 days of the initial hearing because there are deadlines for filing motions and raising defenses. And in those deadlines are missed, the legal defenses that could have been raised will be waived or given up. If defendant is unable to retain counsel of his choosing due to financial indigency, defendant is reminded that he is entitled to court-appointed counsel and defendant will be examined upon request. So you do have to request that. The court notes for the public that when defendant appeared for the initial hearing, he was clad in protective gear. The protection was not to protect defendant from the court. That protection was to protect the defendant from the public. Yes. Until a finding of guilt or judgment of conviction occurs in any case, judgment must be reserved and the presumption of innocence must be respected and preserved. Accordingly, pursuant to Indiana Code 353311(1), the court orders the sheriff of Carroll County to transfer defendant to a facility of the Department of Corrections designated by the commissioner of the department as suitable for confinement of defendant and provided the space is available. So ordered this day, November 3rd, 2022, and signed by Judge Benjamin Diner. We have another order issued. This is his recusal. Order of recusal and certification to the Indiana Supreme Court for selection of a special judge outside of Carroll County. The judge of Carroll County Court has determined that the particular circumstances within the underlying case warrant recusal and dictate that a special judge be appointed in this case. The court hereby recuses itself pursuant to LROA 1319C. This court has determined that no judicial officer within the county may preside over this case. This court now certifies this matter to the Indiana Supreme Court for appointment of special judge in compliance with same citation. So ordered on November 3rd. It does not say verbal judo. It just says the judge of Carroll County Court has determined that the particular circumstances within the underlying case warrant recusal and dictate that a special judge be appointed. When they appoint a special judge is because like Judge Troy Hawkins in Carroll County would be unable, he would under this code, it needs to, for whatever reason, it needs to be someone that is outside of the county of Carroll. I have to start getting rid of these or I'm going to click on them. So then we move to November 2nd of 2022 and a special judge is assigned, Honorable Francis C. Gull. And this is the order by the Supreme Court. Order appointing special judge. The Honorable Benjamin A. Diner, Judge of Carroll County Circuit Court, on his own motion, recuses himself and certifies this matter to the court for appointment of a special judge. And this court, being duly advised, now finds that a special judge should be appointed to hear this matter in the Carroll County Circuit Court pursuant to Indiana Criminal Procedure Rule 13. It is therefore further ordered that the Honorable Francis C. Gull is appointed as special judge to hear this matter in the Carroll County Court. This order vests jurisdiction in Judge Gull. Pursuant to Indiana Criminal Procedure Rule 13E, an oath of office is not required. So basically that she does not have to take an oath of office in Carroll County to preside, to be a special judge in this circumstance. And this was done at Indianapolis, Indiana on November 3rd. Then we move to November 9th of 2022. Correspondence to and from the court was filed. And to Carroll County Circuit Court and those associated. And he lists his cause. This is a letter from the accused to the courts. In the cause listed above, I, Richard M. Allen, hereby throw myself at the mercy of the court. I am begging to be provided with legal assistance in a public defender or whatever help is available. At my initial hearing on October 28th of 2022, I asked to find representation for myself, which is within his rights. However, at the time, I had no clue how expensive it would be just to talk to someone. I also did not realize what my wife and I's immediate financial situation was going to be. We have both been forced to immediately abandon employment, myself due to incarceration and my wife for her personal safety. She has abandoned our house for her own safety. What little reserve there is will fail to even maintain the original residence. Again, I throw myself at the mercy of the court. Please provide me whatever assistance you may. Thank you for your time in this most urgent matter. Sincerely, Richard M. Allen. And this is mailed from White County Jail. November 7th is the date. So as you can see, the time that has elapsed between him requesting to find his own, him sending the letter to the court, and the court getting right back to him is a reasonable amount of time, and it is within the 20 days. So again, nothing awry here. Then we move to November 14th of 2022. There is an order issued. The court finds the unable to hire counsel and is entitled to a court-appointed counsel and investigation. The court appoints Bradley Rossi and Andrew Baldwin as contract public defenders. I will show this, but I'm not going to read it again. It's pretty straightforward, and it is signed by Special Judge Francis Seagull. So, and sorry, that is Rosie, Attorney Bradley Rosie and Attorney Andrew Baldwin as contract public defenders. So yeah, and they are required to appear at the hearing on November 22nd. And we have their appearance filed. So basically this one is just, they're two separate appearances because they were requested to do so by the court. And it's pretty straightforward of just basically, I'm here. I certify that I have served a copy of this document to the county e-filing system upon the Carroll County Prosecutor's Office the 14th day of November of 2022. Signed, Bradley Rosie. And then it's the same basic one for co-counsel Andrew Baldwin. Again, pretty straightforward, no surprises. On November 16th of 2022, a transfer order was issued, and they are not allowing public access to those, which is, I'd assume, pretty standard, just common sense. that you would not want to disclose that. November 18th of 2022, an order is issued, the courthouse management and decorum order for the hearing on November 22nd. And this is basically, I'm not going to read this. It is just basically how the hearing is going to proceed and what is expected, the decorum of how you are going to be conducting yourself in the Carroll County Circuit Court in Delphi. And it goes on, and it's, a pretty standard issue. Like, you're not allowed to record in court, and it is prosecutable, and you will be, just ask Cece, you can be found in contempt of court for doing so. So just, if you are going to attend anything, just, they will say this, but know it in advance. You cannot take your cell phone in there and record, or any kind of device. You can take notes. So take a notepad with you. You will want it, because you can also not use your phone. You can't even have your phone out, at least not in Newton County. And it's very similar to Carroll County. They're both in Indiana. So I would assume it would be the same. We were not even allowed to have our cell phones out. And they had to be powered off. November 22nd of 2022, a petition is filed to let bail filed by the defense. So the defense is representing Richard Allen in this cause, and they have now read the probable cause that was not yet available to the public. Comes now the accused by counsel and pursuant to Article 1, Section 17 of the Constitution of the State of Indiana, Indiana Code 353382, and Fry versus State, and it lists the citation there for that, respectively moves this court to conduct a hearing and then release the accused on his own recognizance, or in the alternative to set a reasonable bail. In support of his petition, the accused avers the following: that the accused, Richard Allen, was arrested and charged with murder on or about October 28th of 2022. That the defense has received and reviewed the probable cause affidavit that as of the time of the filing of this motion has been sealed. That because neither the proof of guilt is evident nor the presumption of guilt strong, the accused is seeking a hearing to release the accused of his own recognizance, or in the alternative to set a reasonable bail. And if you read this 353382 of the Indiana Code, remember going here, and you look up bail, like when you type in that into, oh Lord, never mind. You will see that it says pretty much verbatim this line right here, that because neither the proof of guilt is evident. So this is why they are requesting of them, because they have read this. They feel that the proof of guilt is that it's neither evident nor the presumption of guilt strong, which is the wording of the Indiana Code 353382. Wherefore, the accused by counsel respectfully prays that the court release the accused on his own recognizance, or in the alternative to set a reasonable bail. Respectfully submitted by Andrew Baldwin. And we have an appearance filed. It was a limited appearance for attorneys. Just the, again, this is on the 21st. So they're basically having a conference with the attorneys representing the media interveners or veners and the state and defense. And I'm not going to read this. I'm just going to show it briefly here. Okay. Memorandum brief is filed by media interveners, pre-hearing brief seeking public access to the PCA and the criminal charges information sheet. And again, it's real long and real wordy, and I'm not going to read it all, but it's pretty straightforward of why they're asking for what they're asking for. And again, this has already taken place. Okay, the public and the media have a substantial right to access judicial records based in Indiana policy and the federal and Indiana constitutions, which is true. But the rule of law that was cited in order to have this PCA and charging information sealed is also under rule of law of Indiana. Everything is above reproach thus far. And then we moved to November 22nd when that hearing was held and a motion was filed. So the motion for order prohibiting counsel, enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of the public communication. So this was a request upon the court. Motion for ordering prohibiting the parties' counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication. Now comes Nicholas McClelland, Carroll County prosecuting attorney, first duly sworn upon his oath, and requests the court to prohibit the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extrajudicial statements by means of public communication. In support of said request, the state shows the following. The state filed 2 counts of murder against the defendant on October 28th of 2022 in Carroll County Circuit Court. That the case has received extensive treatment in the local, national, and international news media. The media accounts concerning this cause have contained an undue number of statements relating not only to the progress of the investigation, but conclusions of the investigation, some of which have been untrue. That it is reasonable to believe that the media will continue to cover this cause of action extensively, and that the publicity will prejudice a fair trial. That now we're seeing we've already got a change of venue on the books. So it's like he was a mind reader. That the additional statements and media coverage in the news is likely to produce prejudice in the community, making it impossible to have a fair and impartial jury to ensure that all parties have a fair trial. That an order in place would ensure that the parties abide by Indiana rules of professional conduct, Rule 3.6. That now comes the state of Indiana by Nicholas McClelland, County Carroll prosecuting attorney, and requests the court to prohibit the parties, counsel, law enforcement officials, court personnel, coroner, family members from disseminating information or releasing any extrajudicial statements by means of the public communication until further order of the court and for all other just and proper reliefs in the premises. Dated the 22nd of November. An order is issued, so a proposed order is taken under advisement by the court. So now comes the state of Indiana by prosecuting attorney Nicholas McClelland, filed a motion for order prohibiting the parties, counsel, law enforcement officials. I cannot read that one more time. And you know what it says. The court takes the motion under advisement and sets this matter for a hearing, and it does not disclose when that will occur at this time in the chronological case docket here. There is a order issued, and the defendant appears in person again. This is on November 22nd at the hearing. Some of you guys were there. The defendant appears in person with counsel, Rossi and Baldwin. The state prosecutor, Nicholas McClelland, appears on the petition to prohibit public access filed on October 28th of 2022. The court takes this under advisement, sets petition to let bail and omnibus, so pretrial hearing, on February 17th of 2023 at 10 a.m. So yeah, pretty straightforward. The defendant appears in person with counsel, Bradley Rossi and Andrew Baldwin. The state appears by prosecuting attorney Nicholas McClelland. Hearing held on state's verified request to prohibit public access to a court record filed on October 28th of 2022. That matter, so the matter of the public access, is taken under advisement. The defendant's petition to let to bail, filed November 21st of 2022, ordered set for hearing in the Carroll County Circuit Court on February 17th of 2023 at 10 a.m. Also, there is a separate transport order for that date for the defendant, and the omnibus hearing is rescheduled for that same date of February 17th at 10 a.m. by agreement of counsel. It is signed by the Honorable Judge Francis Gall. Court notes filing a limited appearance by attorneys in his plea and a pleading entitled Media Interveners Pre-Hearing Brief Seeking Public Access to Probable Cause Affidavit and Charging Information on November 21st. Court takes this matter under advisement following the hearing conducted on November 22nd on the state's verified request to prohibit public access to a court record filed on October 28th. So again, pretty straightforward. And the transport order that was mentioned is entered. We do not have access to that. November 23rd of 2022, there's an appearance that is filed. Pretty, just straightforward, just for the clerk's record, for just the integrity of the case. Sometimes you see these types of entries. So the motion to intervene was filed. The media's motion for leave to intervene. And it is, I believe this is exhibit 1, to where when it's, no, this isn't it. It'll be upcoming here. And again, I'm not going to read this. It's pretty, just really straightforward, pretty wordy, pretty long, but yeah. And so that same paper, same document filed by the media interveners now becomes exhibit 1, which just means that the judge is taking it under advisement like we read prior. So now it is becoming a part of the court record as, exhibit 1. On November 28th of 2022, we have a motion for change of venue filed. Defendant files motion for change of venue. We have a verified motion for change of venue from the county. Comes now the accused, Richard Allen, by and through counsel Bradley Rosie and Andrew Baldwin, and pursuant to Criminal 12 of the Indiana Rules of Criminal Procedure, requests that this court change venue from Carroll County. In support of said motion, the accused and his counsel swears and affirms the following. On October 28, 2022, the state of Indiana filed a probable cause affidavit and charging information alleging that Richard Allen murdered victim 1 and victim 2 on or about February 13th of 2027. That the allegations stem from the highly publicized death of 2 Carroll County teenagers. That even before Richard Allen had been accused of these crimes, the matter had been highly publicized. The extensive media attention began while the victims were missing. The extensive media attention continued after the victims were found. The extensive media attention continued for the next 80 months, 5+ years, in a variety of formats until Richard Allen was arrested. Coverage on all local, statewide, and national television media, coverage on local, statewide, and national print media, coverage on several podcasts that reach local, state, national, and international audiences, coverage on the internet in a variety of social media platforms, including Twitter, Reddit, YouTube, and Facebook. The media coverage including multiple press conferences by state and local authorities, including press conference in which the elected prosecutor participated, which is totally common. The extensive media attention continued after Richard Allen was arrested, including the following: coverage on local, statewide, and national television, in print by the media, and a coverage on a variety of social media platforms, including Twitter, YouTube, Reddit, and Facebook. After the arrest of Richard Allen, a press conference was held by the state and local authorities, although it could be argued that the amount of publicity that this particular case has received in the past 5 years will make it difficult to find a jury that has not heard this case. Richard Allen's defense team has gleaned statistical data that would strongly indicate that moving the case trial just 150 miles away would significantly reduce the likelihood of obtaining a tainted jury pool. That since his arrest, data procured from Google Trends and Google Ads details the amount of internet interest through Google searches for Richard Allen, and the data is quite telling. During the month of October, the search for Richard Allen in Carroll County ranged from 1,000 and 10,000 searches for a county with just over 20,000 residents. On average, around 1 in every 2, so 50% of Carroll County residents have conducted online searches of Richard Allen during the month of October following his arrest. Comparatively speaking, Fort Wayne is a city with over 260,000 residents, roughly 13 times the size of Carroll County. In the month of October following his arrest, the average monthly searches for Richard Allen in Fort Wayne range from between 1,000 and 10,000 searches. So on average, therefore, 1 in every 26 residents in Fort Wayne have performed an online search for Richard Allen, compared to 1 in every 2 residents of Carroll County conducting the same internet search of Richard Allen after his arrest. Fort Wayne is less than 100 miles from Delphi, but in that 100 miles, internet searches fell from roughly 50% of residents in Carroll County Googling Richard Allen to less than 5% of residents Googling Richard Allen. This would mean that Carroll County residents have searched Richard Allen over 10 times more often than those residents in Fort Wayne, a city less than 100 miles from Delphi. Presumably, jury pools from county even farther away would have reached Richard Allen. In addition, according to various sources, as many as 300 people were actively involved in the search of the 2 victims while they were missing. The 2022 population of Delphi, Indiana is under 3,000 residents, and therefore it may be the case that as much as roughly 10% of the Delphi population was actively involved in participating for the search of the victims, and presumably therefore arguably heavily invested in the matter and the outcome of the case. Those involved in the search for the victim, in addition to showing a strong investment in the case, arguably could be called as a witness, or at a minimum, their involvement in the search should prevent them from serving on the jury, as they may have information concerning the layout of the area searched that could infect the jury, and have opinions based upon their involvement in the search for the victims. Additionally, arguably, any of the family and friends of anyone involved in the search for the victims could be tainted as well from serving on a jury. Additionally, many Carroll County residents have been involved in some aspects of this case, whether it be in an investigative capacity, police, or as fact witnesses that could have been called as witnesses in the case, or those that searched for the victims, or residents who simply are interested in the matter and have conducted their own independent investigation. Additionally, because of the small number of residents in Carroll County, juxtaposed against a large percentage of population that may have been involved in one of the capacities detailed in the previous paragraph, the likelihood for a tainted jury pool is excessive. During the 5 years following the disappearance of the victims, the Indiana State Police and other law enforcement agencies established an active command post in Delphi to conduct interviews and press conferences, all of which increased the interest in the investigation. This increased exposure lends itself to the tainting of jurors and increased possibility of biased jury panel, which we do not want. While it is impossible for the defense to accurately predict, having received only minimal discovery, it is likely that the law enforcement investigation has conducted possibly hundreds of interviews of potential witnesses and other community members that may or may not have information regarding the crime. Again, the raw number of people in the Carroll County community directly or indirectly involved with the investigation, juxtaposed with the small number of residents in Carroll County, rendered it impossible to find jurors without connection to the case or to someone involved in the case, and without preconceived notions about Richard Allen's guilt or innocence. Oh man. So yeah, if you want to screenshot this and read the rest of it, it's all, I don't know why they tend to just repeat a lot of things, but this one was one that 24 here. Additionally, Richard Allen was a community member who for many years worked at CVS in Delphi. As CVS is the type of business that is commonly visited by the general public, Richard Allen would have come in close contact with many of the Delphi and Carroll County citizens, creating another real concern for a high probability of bias among potential jurors in Carroll County. That Richard Allen Davidsky believes that the best means to avoid a tainted jury pool and to receive a fair veneer for both sides would be to venue the matter to a county of at least 150 miles from Carroll County and to conduct the jury trial in the chosen county. And we see that we have the Honorable Judge Francis Gull has ordered on such. Comes now the court, having received defendant's verified motion for change of venue from the county filed in the matter, and hereby orders that a hearing shall be scheduled for, and we do find out this date here in a little bit. And then we have on November 29th of 2022, we have information that is filed. We have the charging information. So, count one, murder, 3542-112. Nicholas C. McClelland, being first duly sworn upon his oath, says that on or about February 13th, 2017, in the county of Carroll, the state of Indiana, Richard M. Allen did kill another human being to wit, victim 1, while committing or attempting to commit kidnapping of victim 1, all of which is contrary to the form of the statute in such cases made and provided to wit IC 3542(1)(1) parentheses 2, and against the peace and dignity of the state of Indiana. I affirm under penalty or of perjury as specified in IC 35 1 through 2, 1 to 1, that the foregoing representations are true. Signed by Nicholas McClelland. Approved by me this day, October 27th of 2022. My term expires December 31st. He ran unopposed, so his term was up for the election in November, and he will be nothing changes. His next term will continue after this date, and that does not mean anything other than just exactly what I just said. But it was a good question. Someone asked that yesterday in It's a Crime and Shames chat, and it was a good question to ask. Okay, so we're almost to the end here, and I need to step out for a second, and I will be right back, and we will get right into this probable cause. Well, thank you, True Crime Web. We will finish up with reading this and a couple more things, and I will be right back. My mouth is just a little bit dry. So, okay. Here we go. The probable cause affidavit. I, the undersigned affiant, submit the following information pursuant Indiana Code 3533(7)(2) as a sworn affidavit setting forth the facts and circumstances known to law enforcement of Carroll County as the basis for probable cause to arrest without a warrant or to establish probable cause for the issuance of an arrest warrant for the above named defendant, Richard Allen. The facts and circumstances described below will be sufficient basis for a person of reasonable cause and prudence to believe that the accused has committed or attempted to commit the offenses described, and that if arrested without a warrant, such would be authorized under Indiana Code 3533(1)(1). That the hearsay statements of witnesses contained herein are considered reliable and credible due to the witness's personal knowledge and or corroborated by the totality of the circumstances. Totality. On February 14th, 2017, make this a little bigger, victim 1 and victim 2 were found deceased in the woods approximately 0.2 miles northeast southeast of Monon High Bridge in Carroll County. Their bodies were located on the north side of the Deer. At the time, the Monon High Bridge Trail was an approximately 1 mile gravel trail terminating at the Monon High Bridge. The Monon High Bridge is an abandoned railroad trestle approximately 0.25 miles long, spanning the Deer Creek and Deer Creek Valley on the southeast end of the trail. Approximately 0.7 miles northwest on the trail from the northwest edge of the Monon High Bridge is the Freedom Bridge, which is a pedestrian bridge spanning State Road 55. Approximately 350 feet west of Freedom Bridge was a former railroad overpass over Old State Road 25. At that time, it is not there anymore. Old State Road 25, also known as County Road 300 North. Trail terminates just west of the former railroad overpass. The majority of the trail is in a wooded area with a steep embankment on the south side of the trail. The entirety of the trail and the location of the girls' bodies were and are located in Carroll County, Indiana. Through interviews, reviews of electronic review of video at the Hoosier Harvest Store, investigators believe victim 1 and victim 2 were dropped off across from the Mears farm at 1:49 p.m. on February 13th, 2017 by, it's redacted, I'm just going to say blank. The Mears farm is located on the north side of County Road 300 North, near an entrance to the trails. A video from victim 2's phone shows that at 2:13 p.m., victim 1 and victim 2 encountered a male subject on the southeast portion of the Monon High Bridge. The male ordered the girls, quote, "guys, down the hill," end quote. No witnesses saw them after this time. No outgoing communications were found on victim 2's phone after this time. Their bodies were discovered February 14th, 2017. The video recovered from victim 2's phone shows victim 2's phone shows victim 1 walking southeast on the Monon High Bridge while a male subject wearing a dark jacket and jeans walks behind her. As the male subject approaches victim 1 and victim 2, one of the victims mentions gun. Near the end of the video, a male is seen and heard telling the girls, quote, "guys, down the hill." The girls then begin to proceed down the hill, and the video ends. A still photograph taken from the video and the "guys down the hill" audio was subsequently released to the public to investigators in identifying the male. Victim 1 and victim 2 are ruled as homicides. Clothes were found in the Deer Creek belonging to victim 1 and victim 2, south of where their bodies were located. There was also a 40 caliber unspent round less than 2 feet away from victim 2's body, between victim 1 and victim 2's bodies. The round was unspent and had extraction marks on it. Interviews were conducted with 3 juveniles. Blank and blank. They advised they were on the Monon High Bridge Trail on February 18th of 2017. They advised they were walking on the trail toward Freedom Bridge to go home when they encountered a male walking from Freedom Bridge toward the Monon High. Blank described the male as kind of creepy. That's in quotes. And advised he was wearing like blue jeans and like a really light blue jacket, and it was gray and maybe a little brown, and he did not really show his face. She advised the jacket was a duck canvas type jacket. Blank advised she said hi to the male, but he just glared at them. She recalled him being in all black and had something covering his mouth. She described him as not very tall with a bigger build. She said he was not bigger than 5'10". Blank advised he was wearing a black hoodie, black jeans, and black boots. She stated he had his hands in his pockets. Blank showed investigators photographs she took on her phone while she was on the trail that day. The photographs included a photo of the Monon High Bridge taken at 12 3 p.m. and another one taken at 1:26 p.m. on the bench east of Freedom Bridge. Blank advised after she took the photo of the bench, they started walking back towards Freedom Bridge. She advised that was when they encountered the man who matched the description of the photograph taken from the victim two's video. Blank described the man she encountered on the trail as wearing a blue or black windbreaker jacket. She advised the jacket had a collar and he had his hood up from the clothing underneath his jacket. She advised he was wearing baggy jeans and was taller than her. She advised her head came up to approximately his shoulder. She advised Blank said hi to the man and that he said nothing back. She stated he was walking with a purpose, like he knew where he was going. She stated he had his hands in his pocket, head down. She advised she did not get a good look at his face, but believed him to be a white male. The girls advised after encountering the male, they continued their walk across Freedom Bridge and onto the road bridge over Old State Road 25. Investigators spoke with Blank, who advised she was on the trails on February 13, 2017. Video from the Hoosier Harvest Store captured Blank's vehicle traveling eastbound at 1:46 toward the entrance across from the Mears farm. Blank advised that she saw 4 juvenile females walking on the bridge over Old State Road 25, and she was driving underneath on her way to park. Blank advised there were no other cars parked across from Mears Farm when she parked. She advised she walked to the Monon High Bridge and observed a male matching the one from victim two's video. She described the male she saw as a white male wearing blue jeans, a blue jacket. She advised he was standing on the first platform of the Monon High Bridge, approximately 50 feet from her. She advised she turned around at the bridge and continued her walk. She advised approximately halfway between the bridge and the parking area across from Mears Farm, she passed 2 girls walking towards Monon High Bridge. She advised she believed the girls were victims 1 and victim 2. Videos from the Hoosier Harvest Store shows at 1:49 a white car matching vehicle traveling away from the entrance across from the Mears farm. Blank advised she finished her walk, saw no other adults other than the male on the bridge. Her vehicle is seen on Hoosier Harvest Store video at 2:14 p.m. leaving westbound from the trails. Blank advised when she was leaving, she noted a vehicle was parked in an odd manner at the old Child Protective Services building. She said it was not odd for vehicles to be parked there, but she noticed it was odd because of the manner it was parked. Backed in near the building, investigators received a tip from Blank in which he stated he was on his way to Delphi on State Road 25 around 2:10 p.m. on February 13, 2017. He observed a purple PT Cruiser or small SUV type vehicle parked on the south side of the old CPS building. He stated it appears as though it was backed in as to conceal the license plate of the vehicle. Blank both drew diagrams of where they saw the vehicle parked, and their diagrams generally matched as to the area the vehicle was parked and the manner in which it was parked. Blank advised he remembered seeing a smaller, dark-colored car parked at the CVS building. He described it as possibly being a smart car. Blank vehicle is seen leaving at 2:28 p.m. on the Hoosier Harvest Store video. Investigators spoke with Blank, who stated that she was traveling east on 300 North on February 13, 2022, and observed a male subject walking west on the north side of 300 North, away from the Monon High Bridge. Blank advised that the male subject was wearing a blue-colored jacket and blue jeans and was muddy and bloody. She further stated that it appeared he had gotten into a fight. Investigators were able to determine from watching the video from Hoosier Harvest Store that Blank was traveling on County Road 300 North at approximately 3:57 p.m. Through interviews, electronic data, photographs, and video from the Hoosier Harvest Store, investigators determined that there were other people on the trail that day after 2:13. Those people were interviewed, and none of those individuals encountered the male subject referenced above, witnessed by the juvenile girls blank and blank. Further, none of those individuals witnessed victim 1 and victim 2. Investigators reviewing prior tips encountered a tip narrative from an officer who interviewed Richard M. Allen in 2017. That narrative stated, Mr. Allen was on the trail between 13:30 and 15:30. He parked at the old Farm Bureau building and walked to the new Freedom Bridge. While at the Freedom Bridge, he saw 3 females. He noted one was taller and had brown or black hair. He did not remember the description, nor did he speak to them. He walked from Freedom Bridge to High Bridge. He did not see anybody, although he stated he was watching a stock ticker on his phone as he walked. That's a treacherous thing to do as you're walking out there on that dirt trail. He stated there were vehicles parked at the High Bridge trail head, however, did not pay attention to them. He did not take any photos or video. His cell phone did not list an IMEI, but did have the following, and it lists a series of numbers. Potential follow-up information. Who were the 3 girls walking in the area of Freedom Bridge? Investigators believe Mr. Allen was referring to the former Child Protective Service building, as there was not a Farm Bureau building in the area, nor had there been. Investigators believe the females he saw included blank and blank due to the time they were leaving the trail, the time he reported getting to the trail, and the descriptions the 3 females gave. Investigators discovered Richard Allen owned 2 vehicles in 2017, a 2016 black Ford Focus and a 2006 gray Ford 500. Investigators observed a vehicle that resembled Allen's 2016 Ford Focus on the Hoosier Harvest Store video at 1:27 p.m. traveling westbound on County Road 300 in front of the Hoosier Harvest Store, which coincides with his statement that he arrived at 1:30 at the trails. Investigators note witnesses described the vehicle parked at the former Child Protective Service building as a PT Cruiser, small SUV, or smart car. Investigators believe those descriptions are similar in nature to the 2016 Ford Focus. On October 13, 2022, Richard Allen was interviewed again by investigators. He advised he was on the trails on February 13, 2017. He stated he saw juvenile girls on the trails east of Freedom Bridge and that he went on the Monon High Bridge. Richard Allen further stated he went out on the Monon High Bridge to watch the fish. Later in his statement, he said he walked out to the first platform on the bridge. He stated he then walked back, sat on a bench on the trail, and then left. He stated he parked his car on the side of an old building. He told investigators that he was wearing blue jeans and a blue or black Carhartt jacket with a hood. He advised he may have been wearing some type of head covering as well. He further claimed he saw no one else except for the juvenile girls he saw east of the Freedom Bridge. He told investigators that he owns firearms and they are at his home. Richard M. Allen's wife, Kathy, also spoke to investigators. She confirmed that Richard did have guns and knives at the residence. She also stated that Richard still owns a blue Carhartt jacket. On October 13, 2022, investigators executed a search warrant of Richard Allen's residence at, I chose to blank that out, Drive in Delphi, Carroll County, Indiana. Among other items, officials located jackets, boots, knives, and firearms, including a Sig Sauer Model P226 .40 caliber pistol with a serial number of U625627. Between October 14th, 2022 and October 19, 2022, the Indiana State Police Laboratory performed an analysis on Allen's Sig Sauer Model 226. The laboratory performed a physical examination and classification of the firearm, function tests, barrel and overall length measurements, test firing, ammunition component characterization, microscopic comparison, and NIBIN. The laboratory determined the unspent round located within 2 feet of the victim's body had been cycled through Richard M. Allen's Sig Sauer model P226. The laboratory remarked, an identification opinion is reached when the evidence exhibits an agreement of the class characteristics and a sufficient agreement of individual marks. Sufficient agreement is related to the significant duplication of random strided impressed marks as evidenced by the correspondence of a pattern or combination of patterns of surface contours. The interpretation of identification is subject in nature and based on relevant scientific research and the reporting examiner's training and experience. Investigators then ran the firearm and found that the firearm was purchased by Richard Allen in 2001. Richard Allen voluntarily came to the Indiana State Police Post on October 26 of 2022. He spoke with investigators in the and stated that he never allowed anyone to use or borrow the Sig Sauer model P226 firearm. When asked about the unspent bullet, he did not have an explanation of why the bullet was found between the bodies of victim 1 and victim 2. He again admitted that he was on the trail but denied knowing victim 1 or 2 and denied any involvement in their murders. Carroll County Sheriff's Department Detective Blank has been part of the investigation since it started in 2017. He has had an opportunity to review and examine evidence gathered in this investigation. Detective Blank, along with other investigators, believe the evidence gathered shows that Richard Allen is the male subject seen on the video from victim 2's phone who forced the victims down the hill. Further, that the victims were forced down the hill by Richard Allen and led to the location where they were murdered. Through the statements and photographs of the juvenile females and the statements of Blank and where at the southeast edge of the trail at 12:43 p.m. east of Freedom Bridge at 1:26 p.m. and walked across the former railroad overpass over Old State Road 25 at 1:26 and before 1:46 p.m. They walked the entirety of the trail and observed only one person, an adult male. Blank's vehicle is seen on Hoosier Harvest Store video at 1:46 p.m. and leaving at 2:14 p.m. And she stated she only saw one adult male. Blank described the male in similar manners, wearing similar clothing, leading investigators to believe all four saw the same male individual. Investigators believe the male observed by Blank is the same male depicted in the video from victim 2's phone due to descriptions of the male by the four females matching the male in the video. Furthermore, victim's 2's video was taken at 2:13 p.m. and Blank saw only one male while she was on the trail from approximately 1:46 to 2:14 p.m. Investigators believe Richard Allen was the male seen by Blank and the male seen in victim 2's video. Richard Allen told investigators he was on the trail from 1:30 to 3:30 that day. Video from Hoosier Harvest Store shows a vehicle that matches the description of Richard Allen's vehicle passing at 1:27 toward the former CPS building. The clothing he told investigators he was wearing matched the clothing of the male in victim 2's video and the clothing descriptions provided by Blank. A vehicle matching the description of his 2016 Ford Focus is seen at or around 2:10, 2:14, and 2:28 p.m. at the former CPS building. Through his own admissions, Richard Allen walked the trails and eventually hiked to the Monon High Bridge and walked out onto the Monon High Bridge. A male subject matching Richard Allen's description was not seen. Crucial. A male subject matching Richard Allen's description was not seen on the trail after 2:13. Investigators identified individuals on the trails or County Road 300 North between 2:30 and 4:11 p.m. None of those individuals saw a male subject matching the description of Richard Allen on the trail. Furthermore, Richard Allen stated that he only saw 3 girls on the trail who investigators believed to be blank, blank, blank. Investigators believe Richard Allen was not seen on the trail after 2:13 because he was in the woods with victim 1 and 2. An unspent .40 caliber round between the bodies of victim 1 and victim 2 was forensically determined to have cycled through Richard Allen's Sig Sauer model P226. The Sig Sauer model P226 was found at Richard Allen's residence, and he admitted to owning it. Investigators were able to determine that he had owned it since 2001. Richard Allen stated he had not been at that property where the unspent round was found, that he did not know the property owner, and that he had no explanation as to why a round cycled through his firearm would be at that location. Furthermore, he stated that he never allowed anyone to use or borrow the Sig Sauer model P226. Investigators believe that after the victims were murdered, Richard Allen returned to his vehicle by walking down County Road 300 North. Investigators believe he was seen by blank walking back to his vehicle on County Road 300 North with clothes that were muddied and bloody. Blank, along with the investigators, believe the statements made by the witnesses because the statements corroborate the timeline of death of 2 victims, as well as coincide with the admissions made by Richard Allen. Further, the accounts relayed by blank and blank are similar in nature, and timestamps on photographs taken by blank correspond to the times juvenile females said they were on the trail and saw male individual. And that is page 7. This is page 8. Carroll County Circuit Court, dated October 27th of 2022. The court will please enter the following minutes. The State of Indiana by Nicholas McLeland, prosecuting attorney, files probable cause affidavits executed by Tony Liggett and information for count 1, murder, a felony, and count 2, murder, a felony. The defendant being in custody, the court determines the probable cause does exist. The court sets bond in this matter at, and it doesn't say, but it is the probable cause. And I'm assuming that there, because it doesn't say and it doesn't have a signature, that there is another one that was submitted on October 28th. And this is what we, the public, including the media, are there, have the judge to act. It does say 1 of 8. It doesn't say 1 of 12, to where you could reasonably determine that there are missing pages. It says there are 8 pages, and guess what? There's 8 pages. Okay, I'm going to go get that Tylenol. I don't know what happened. Didn't hit anything. It's probably my internet connection. So I will be right back. Just got to run to the kitchen. It'll only take 30 seconds. Mm. Glossing up for Adam and Sunny. Okay. Woo. No storms, just my internet connection. But go ahead and read this press release we got on the record for people that don't want to listen to our conversation afterwards, where I will talk to the chat. Okay. As Rick, Allen's attorneys, we have received multiple requests from local and national media for interviews and comments since the unsealing of the probable cause affidavit. I'm going to try just like not having my camera on and see if that helps with my connection issues. I have one bar. Hopefully it's not breaking up. We shall see. Richard contacted police to let them know that he had walked on the trail that day, as he often did. Without Richard coming forward, the police probably would not have had any way of knowing that he was on the trail that day. Richard volunteered to meet with a conservation officer. What happened now? Is it not working? Sharing my screen? Is this not going to work? Richard volunteered to meet with conservation officers outside of the local grocery store to offer up details of his trip to the trail on the day in question. Richard tried to assist with the investigation and told the police that he did recall seeing 3 young girls on the trail that day. His contact with the girls was brief and of little significance. Okay, well, I don't know what the deal is. So can you guys hear me? You can't hear me, can you? Let me know if you can hear me. Okay, you can hear me. Where was I? Over that. Richard does not recall if this interaction with the conservation officer was tape recorded, but believes that the conservation officer scribbled notes on a notepad as Rick spoke to him. After Richard shared his information with law enforcement officials, he went back to his job at the local CVS and didn't hear from the police for more than 5 years. The next time Richard heard from the police was in October of 2022. This was approximately 2 weeks before a contested sheriff's election and within days of a federal lawsuit filed against the Carroll County Sheriff's Office by its former second-in-command, Michael Thomas. In the lawsuit, Thomas claimed that he, Thomas, had made suggestions and offered assistance in the investigation of a high-profile child homicide investigation, but those suggestions and offers were rejected by the sheriff. Thomas further claimed that the sheriff and others in the department feared the disagreements with Thomas would become publicized as a result of the political campaign for sheriff. Thomas claims in the suit that he was ultimately demoted and replaced by Tony Liggett, who later that year won the 2022 election for sheriff. Furthermore, Thomas claims he was also removed from high-profile cases. Richard was ultimately arrested on October 28th of 2022. In the 5+ years since Richard volunteered to provide information to the police, Richard did not get rid of his vehicle or his guns and did not throw out his clothing. He did not alter his appearance. He did not relocate himself to another community. He did what any innocent man would do and continued with his normal routine, or a psychopath would also do that. The probable cause affidavit seems to suggest that a single magic bullet is proof of Richard's guilt. It is a bit premature to engage in any detailed discussions regarding the veracity of this evidence until more discovery is received, but it is safe to say that the discipline of tool mark identification, ballistics, is anything but a science. The entire discipline has been attacked in courtrooms across the country as being unreliable and lacking any scientific validity. We anticipate a vigorous legal and factual challenge to any claims by the prosecution as to the reliability of its conclusions concerning the single magic bullet. On Richard's behalf, we argued to have the PCA unsealed. Richard has nothing to hide. As importantly, we were hoping that we would receive tips that would assist us in proving up his innocence. Not surprisingly, we have been inundated with tips from a variety of sources, all of which will be vetted by our team. Although it is of the prosecution to prove Richard's guilt beyond a reasonable doubt, the defense team looks forward to conducting its own investigation concerning Richard's innocence. We appreciate those that have reached out to support his cause. The prosecutor mentioned at the last hearing his belief that others may have been involved in the killing, yet there was no mention in the PCA about a second suspect involved in the killing. The defense is confused by such discrepancies in the investigation and will be in better position to respond as more discovery is received. Richard Allen owned a Ford Focus in February of 2017. His Ford Focus is not in any way similar to the distinctive look of the PT Cruiser or smart car that was described by the witnesses. It seemed that the CCSD is trying to bend facts to fit their narrative. At this point in time, we have received very limited information about this case and look forward to having something more to view than that which was offered up in the sparse PCA. Moving forward, it is our intent to scrutinize the discovery as it is received and give the necessary attention to the volumes of tips that we are receiving. To the extent we continue to discover information that points to Richard's innocence, we will offer up this information to the public so long as we are not prohibited from doing so as a result of the recent request by the prosecutor for a gag order or by the Indiana Rules of Professional Conduct. Signed, Brad Rosie and Andrew Baldwin. Attorney Richard Allen. So, yeah. And just the family just got home. Okay, so that took me an hour and 42 minutes at 1.5 speed. I think you'll be able to understand me and get through that a little bit quicker. But that wraps up the reading of the chronological case summary and information available to the public on the case of Richard Allen, the alleged murderer of Abigail Williams and Liberty German on February 13th of 2017 in Delphi, Indiana, county of Carroll. Okay, and now we're just going to talk for a little bit and catch up with the chat. I saw some super chats coming in, so those first. Oh, is it not going to let me go back that far? I'm so sorry, guys. Yep, it's not going to let me. So on my next live, I will be thanking you personally for and reading what you had to say. I didn't realize that it would do that. Hey, Lipsha. Hey, CJK. Lighting the way home. Cindy, how are you? Carol. Hey, CD, analysis of a crime. Good to see you. Kimosabi, hello. Diamond eyes. Ooh, pretty. Grandma watches. Hello. Cher. Hi, Cher. Crimezilla. Hello. And Professor Pug. Hello. And lighting the way home for the vanished. Georgina. Hello. Polygraph. Wow. Lots of people here tonight. Digger Dave. Aspen. Hello. Tech Death. Hello. Digger Dave says his own statements are going to be the difference. Yeah, as long as the one that was taken in a grocery store parking lot is admissible. Why? Hello? Yeah, right. I can see like my internet connection. We've been having trouble with our TV too. Like it's doing it right now. So it says connection is unstable. So I am not surprised one bit. Where does the money for the defense come from? Not to pay the attorneys, but to pay for other things like PIs, experts, etc. Yeah, good question. It comes from the state of Indiana, so taxpayers. Yeah, that's just a part of the investigation. It was actually in one of the court documents that I read. But if anyone wants to join me for a very brief little few bit, feel free to jump on and let me hear your thoughts and let's discuss what all we just read. It was quite a lot. You will have to show your face. You show up down here when you're not in the screen in order for me to let you on. I want to see that you are not naked or something crazy. So if you're not willing to do that, then don't bother hitting this. But you just have to do it for a brief moment. Then you can, as long as I see and I say I see you, then you can turn your camera off and join the stream. Yes, please hit the thumbs up button. Yes, she works relentlessly. Victims of crime and deserves our appreciation. And I know I'm a fangirl, but y'all just hit the thumbs up. Yes, thank you. Thank you, Aspen, who is a moderator now. So true about the algo. Oh, here we go. Hello.
Hello.
How are you doing tonight?
I'm currently brushing my dog's legs.
Oh, sounds titillating.
So much fun. Yes. I figured I don't really have anything specific to say. I just figured I would jump on to discuss whatever came up.
Yeah. We already got a question. Do you think they have a strong case against RA? I think that what was presented in the probable cause is enough for what was stated in those don't you? I think it was enough for arrest and the charges. And I think that the discovery and all of the other evidence that they have strategically held back, which is just a sign of good prosecution, will show us a lot more of the evidence that they have, you know.
Before I give my opinion, if I mute all of a sudden, it's because my other half should be getting home any minute and the dog will start
Okay.
when he hears the doorknob and all that.
Gotcha.
I was watching, I forget their name, something about paranormal, afterlife, something or other. They talk about cases though. And they had on, oh, there it goes. Be quiet. That they had on, oh, what is their name? The prosecution. I don't know. They're like lawyers. They have a channel. I forget their name. What'd you say?
Awesome.
Oh, sorry. I thought you said the name of them. So they had them on, and one of them, I don't know if it was one of them or if it was their other guest, they said that that's how a lot of probable causes are, that they put as much in there as they need to make the argument that it's probable. So like 51% basically, that the person did it, and they keep out everything else. And if it wasn't like that, that it would have been overkill, which kind of surprised me. So I think it's based on that, it's enough. And I'm sure they have much more information. Oops, there it goes. Sorry. I'm sure they have much more in discovery and all that.
I think so. I think that it's, you know, everything has a time and a place with these cases and the way that they will be meted out. Like, we don't even know yet. But I think that everyone needs to keep in mind, like what I just read. Like, obviously, that is the defense. Obviously, the press conferences and statements made were made for the purpose of keeping the public's eye on a case that is unsolved and totally a normal, expected thing. And they're trying to but see how they can twist that to well, we haven't had a chance to talk. And they're right. But the jury of his peers will be meting out guilty or not guilty unless he decides to take a plea. Even they admitted they do not have the full case, which does take time, and it will, in due time. And it is not anything that they are withholding. It is just the court's process. So everything that's happened is totally normal so far. They can't.
I did think that, I think it was Gray who made this point. Mm-hmm. He said that they didn't say how they died. They just said that it was a homicide, which I didn't really think about when I read it, by myself, because we have all this information that we already know. But if you were to read that and you had no knowledge of the case beforehand, how would you think that they were killed?
Based on
just the probable cause.
Well, a bullet.
Yeah.
Well, but see, it's an unspent casing, so it's basically.
Yeah, even then. But that's really the only. Yes, Chris, Prosecutor's Podcast. I could not think of it. That's right. But yeah.
But we also have the information that was recklessly released in the Ron Logan affidavit. While Ron Logan is innocent, it does state in there specifics to the case that would not be a lie,
I just meant specifically in that probable cause, because when Gray was talking about it, he was talking about how it was weird, because usually in those, I think he said he had talked to Ives about it, and Ives had said it was kind of weird, because usually probable cause they have to explain the basics of the crime and what happened. Mm-hmm. 2 people were killed by knife or whatever, and then they explain why they're connecting the person to it.
Oh. And then I see what they're meaning, but I think they did in a roundabout way without saying the specifics, they did give enough specifics, and I don't know. But I lost it.
Now that I say that out loud, though, I wonder if it would have been weird. I mean, I guess only a judge is really looking at it, but it probably would have been weird had you said that they were killed by a knife, specifically said that, and then said that like one of your biggest pieces of evidence was a unspent bullet.
Right. I think that just like places him there. And and I remembered my point. Between what was that? October 20
8th, 7th, something like that.
when was he interviewed? The 22nd or 26th?
I can't remember.
And the search warrant, that when did they do the search warrant? Was it, I think it was like 27th or 22nd. He was interviewed on like the 13th. They did a search in that time. And then he was arrested, like they brought him for questioning on the 27th, and then arrested and charged before a judge on the 8th. So is that enough? And we know that they collected knives, guns, clothing from his home. That's what it says in there. It doesn't, but it could also, I mean, we do know from the Ron Logan one that they found, like, it is easy to assume from that probable cause that there were fibers that they were also searching for, and
yes,
hairs from animal or whatever. Okay, I'll get you right in a second. I just want to get this thought out because my ADHD brain won't allow it. But that just basically the DNA, like, is probably was still in the process of being processed at the time that the probable cause. But when you have a suspect of a brutal double homicide, you want to get that person off of the street as soon as you possibly know to get them off the street. So I think it's reasonable that when they process that stuff, there's likely going to be more fibers, hairs, and DNA to link him to the crime.
I agree. I mean, I think they have way more than that. I did want to say to, where was it, Carroll, that because this has been something that's come up, and this is, I'm not a lawyer, this is just my opinion based on how I've read Indiana law. People have been using the phrase felony murder, but that's a generic phrase. Because the United States is weird, because I know Carroll specifically is in Australia. So the United States is weird because each state has their own laws, and they're similar but unique to each state still. If you go read Indiana law, the one he was charged with, I can't remember word for word, but it says that person killed another person while also committing a crime of, and then it's got a list, and for the particular one, it was kidnapping.
Yeah.
So it says that he killed them. But other states, they have like what they call felony murder, where let's say you're like the getaway driver and somebody dies during the robbery, then that's that felony murder. But this is a tad bit different and more specific to actually killing somebody.
Yeah. Yeah, Jack Green, that's a good point. They have not released that probable cause affidavit, which they won't.
No.
Those are, not so recklessly released. And I think that was intentional. I think it was leaked on purpose. And I do think that those were released for the purpose of the Carroll County happenings. But I don't think suggesting that was obviously the defense is going to try to say whatever they want. But I don't think that, I think that it was something that they obviously like found out about, that he was re-interviewed as soon as they got that information, and the timing is just of no consequence. It's no coincidence. It's not.
Well, Ron's, it wasn't leaked, like it wasn't public knowledge, but when they search your house, they give you a copy of it, and he let certain people see it. Like that, it's just if you knew the people or not, and if you could believe that they were telling you the information correctly. And so that means the Allens have it. I don't think they'll be sharing it, but it also could be one of the many reasons why the prosecution is requesting a gag order so that they can't.
Lighting the way home. He's charged with double murder and kidnapping. But I do understand what you're saying about like they may have more charges, and that is typical. I've seen that happen in quite a lot of cases in Indiana and other states where they will add on more charges. So hey Crimezilla, how are you?
Hello, I did not want to interrupt. I'm sorry.
Oh, I just wanted to get that. I kept losing that thought about the timing and when like the DNA would be able to be processed, and because it depends on what type of DNA it is too, and how far they have to work on that profile in the lab. It could take a few days, it could take a few weeks, you know. Oh, I'm gonna sneeze.
Oh, hi, Ivy.
Hello.
How are you?
Good. How are you?
Hanging in there. Hanging in. Just
See, oh, by the way, your picture is really pretty.
oh, thank you. That would be Tennessee.
It's very
Oh,
nice.
Thank
that
you.
does. It fits perfectly.
It does,
Cool.
doesn't it? I
That's
just
cool.
found it. I got to get back and go find my crime.
But to give my opinion real quick on Professor Pug, what she said. Oh, if I'm going to be able to find it. I think that the prosecution has an A team too, and I think that we need to support McClelland. I think he has done a lot of strategic moves, and he does not give two forks about what we, the public, think. And he's done some things so far that I'm kind of like, I see you. Like, I know what you're doing here. And I think he's done a phenomenal job so far. And he's the only one that I would want on this case because his heart is in it. And that makes a world of difference. And he is the one that knows the most about this case. And he is a highly intelligent man. So I think that I get it why people, you know, like are not super competent, you know, but he was also a defense lawyer before he became a prosecution.
Ooh, that's nice.
And a prosecutor. So I think that that is going to give him a leg up as well, because he knows what they're going to do before they do it, because he was on that side. And I think that's why things playing out the way that they are. He knows how to volley, if you will, volley back and forth with the defense, and the defense is doing a good job of defending their client, which we want them to do, you know.
And for as much as said about Ives and him being like a lot of the prosecutor that a lot of people think about, he was off. He had retired by the end of 2017, wasn't it? So McClelland has been on the case, even though we haven't heard his name quite as much, for the like 4 or more out of the 5, almost 6 years.
Right. Yeah. He has. You know, and that's I think that I think that he's already had multiple mentors and counsel with his fellow peers, you know, and I think he'll probably have a co-counsel as well. You know, probably see, you know, it'd be kind of cool to see Ives. Although if we're going to get someone, I think we should get someone that has, you know, tried a few murder trials that are similar to this one. I recommend Drinsky. Just saying. He'd probably be so mad at me if he knew that I was over here saying that. Like,
I don't even know who you're talking about.
The Newton County. He's tried the murder trials of Garrett Kurtz, and not that one pled down, which he did expertly, but Ashley Garth, and then 2 other, like a double homicide in Newton County.
Was that Newton County? I thought that was, I guess maybe that was where Ray's case was. Was that a different county?
It was a long time ago. It was just something that I had found when researching Prosecutor Drinsky in Newton County, but that he successfully tried other murder cases, and one that was kind of similar to just having all of these people, you know, in the Nicole Bowen case. Like, you've got multiple offenders killing the same victim.
Mm-hmm.
And so, is a capital case different if it's death? Well, capital is like death penalty, and that is in Indiana. You would make put the courts on notice that you will be seeking the death penalty, and then it would become a part of the trial, but the jury would make a separate decision upon the sentencing, whether they are going to so they would, if they find him guilty, then that would be a deliberation that they have amongst themselves. And then they will have a separate deliberation on whether whether they recommend the death penalty.
I hope he just gets life without
Yes.
parole.
Indiana does have the death penalty. I mean, I hope that it was confusing to me with the petition to let bail, because I think it's not a meaningful bond hearing. And so I'm kind of thinking that it is the defense arguing the presumption of guilt. Is it strong enough for no bond on murder? But I don't think that necessarily means that the prosecutor is going to have to release more of the case before he's ready to do so. And by ready, I mean the appropriate timing. I'm sure he's ready, and I'm sure they are continuing to get even more ready, but they're ready. But like you can never be prepared enough. You just always want to.
See, I thought it was and I'm not that versed in legalities and whatnot, but I thought it was a play to force them to have to release information out of the probable cause as a backup if the probable cause was kept sealed.
See, I don't think I'm following you, because I was like not listening all the way. I'm sorry.
Oh, I just
say it again.
I thought that it was on the defense's part, I thought they were trying to force the prosecution to give the information that was in the probable cause if the probable cause had been sealed by the judge. I thought that was their like backup plan. And that's why they did that, whatever you're just talking about.
Yeah. Makes sense. I don't know. I think that I just feel like he's done some things that I think they'll bode well in the long run of when we can look back in retrospect. And frankly, we don't know. We don't know what happened. I mean, I'm a little taken aback by some of the things I read in that probable cause, of just about like meeting in a grocery store parking lot and a conservation officer scribbling down some notes. That's super worrisome. Because like with what he said then and what he said now, what they're wanting to do is create that like, here's what he said then, and then he changed that. So it's like, if you're going to go on his statements, that statement should have been, and then just okay. So if you're Richard Allen and you don't realize that they have your video, like that the person that you just murdered took a video of you, right? So he probably saw that and freaked out, and then decided, oh, I better get down there and say something of like, oh yeah, I was out there, because obviously I was, they freaking saw me. But you got to remember, back then they didn't release like the recording in the beginning. They just released the stills of the person, and they were just asking for that person to come forward. And so he probably thought, I better do that or I look super guilty. And if I go getting rid of stuff, I look even more guilty. If I go getting rid of my car and my coat and my jeans and my boots, Um, and also I just think that like psychopaths, if that is what he is, like say he is the killer, because he is just alleged right now, they do that. They don't think like normal people. So business as usual and inserting themselves into an investigation are common things that they will do. That's how they get away with it.
What about the bullet though? Because didn't he tell them when he talked to him about him not letting anybody else use the gun and that he still had it? Wasn't that in October, like this year?
I can't. Yeah.
So like he knew that they had investigated that scene. So let's say, like, hypothetically, let's say he knew that he lost a bullet out there. Why would you say that you never, like, wouldn't you try to be like, well, I have it in a bag and it's over here and anybody has access to it, but
yeah,
I haven't used it in a while, or I don't know.
I think that he thought he was being super careful. And when say that he did cock his gun in his pocket on the bridge to scare them.
Mm-hmm.
Like, because they said gun, and then he took that ejected round, which would be an unspent casing, and he put it in his pocket, and it fell out at the crime scene.
Well, if he, like, basically, because you're talking about like he chambered around when he pointed the gun initially on the bridge at the girls, right?
Yeah.
If it wasn't already loaded, though, it would just put one in the chamber. It wouldn't eject one.
Yeah, but I know how many times I have, because it's just muscle memory. Like when you just practice all the time, like that's how you practice, is chambering around every time, and so it could have just been out of like habit that he didn't realize that it was already loaded. And so now I've got a bullet and I'm going to put that in my pocket, and it fell out at the crime scene. I don't know.
Would he bend down and pick it up though? Like if you did that, you wouldn't be able to catch it. I mean, I don't think.
Well, it's got a hammer cock on it, Professor Pug.
Yeah.
So it does cock.
That's the other thing. Maybe he just cocked it with the hammer.
Not a whacking the slide, if that's what I said, but
I don't know. I have so many questions about that. I don't know if we'll ever have the answer on that one, but
yeah. Yeah, I think, and the thing is that they could have done fingerprint analysis on it after that probable cause they could have that as well. And they don't have to put that in the PCA. So they could have a fingerprint, they could have touch DNA from the fingerprint, they could have blood from the victim on it, they could have blood from his clothing, hair fibers and hairs. There's a lot of other potential evidence that I think that, like this is just a piece of the totality.
Mm-hmm.
And it even says it in there, the totality of the circumstances.
Yeah.
You got a lot of, it's not like you have one eyewitness, you have multiple. So that is helpful too.
I agree. And I had a question I think it was, sorry, I got sidetracked by Professor Pug's thing. I think it was Professor Pug. I can't remember who it was, but somebody said that one of the witness times didn't line up with the rest of the timeline. But I never figured out who they were talking about. So if whoever said that is in the chat, if you could put it in, that would be great.
I was reading Grandma. Oh, wait. So I was listening to a few attorneys on, it was really nice because it was one defense attorney and one prosecuting attorney. And it was nice to hear them go back and forth, and they all get along, but it was nice to hear it from both sides.
Was that on the Paranormal Afterlife?
Yes.
I was just talking about that one a minute ago.
Yeah. And so it was just really an interesting perspective for me to see how each side is going to probably present their case And the ballistics, it's interesting to hear about that with the bullet. I was always taught that each gun and bullet would have their own, I don't want to say identity. What do I want to say, Ivy?
Like it puts its own markings.
It puts its own marking on it.
Yeah, and I totally agree. It's just it's gonna get it's
I want
like,
to see the
it's
science behind
potentially
that.
gonna it's
Yeah.
50-50 that it will be even admissible at a jury trial. So therefore it's going to be moot because the jury will not be able to even know about it, let alone reach a conclusion about it, because it is not an exact science. And I understand like both sides can have an expert witness, like
Mhm.
how many times have we seen that in other cases? Like just think of the Casey Anthony case. That expert witness has said this, and the expert witness said this. And you're like, they're polar opposite opinions because they're just opinions, and that's literally what the report said. Like, it's an opinion and it's subjective, which
Subjective
means
is keyword.
it's subjective is the key word. Maybe people don't know what that word means, but it's just like it is subjective to the person. It's their opinion. It's subjective to critique,
Because like when you shoot the bullet, I think that's where they have the rifling down the barrel, and then the shell casing, like when the gun's actually fired, there's the marks from the firing pin, I believe, and then also the marks from the ejector. But since this wasn't fired, they can't look at any rifling, I don't think, and they can't look at the firing pin mark. It's just from the ejector and whatever else it hits going from the magazine to the chamber.
Yeah. So I just get confused by the unspent casing, because doesn't that just mean like a casing is what is the outside, like the shell of a bullet? Like, isn't that just an unspent bullet? Like,
Yeah, but did it say casing in the probable cause?
yes. Didn't it?
Hold on, I'm going to look, because I figured it would be like an unspent round or like
an unspent 40 caliber round. So yeah, bullet.
But people are using casing, and that's why some people get confused about, well, does that mean they were shot?
That's a good point.
Oh, another thing, I'm sure it means absolutely nothing, but there was an old Farm Bureau building. I don't know how long ago it was, but it was just down the road a little bit, not too far, on the corner, like Highway 25, which is the Hoosier Heartland Highway that Freedom Bridge goes over. That intersects, I think it's 421, I think is the other highway. And where that intersects, I think it's the northeast corner, that there was a building called Carroll County Farm Bureau. So I was surprised to see that after in the probable cause it says there wasn't ever one. Not that it makes a difference, but it would change the direction in which he walked, because that's like the opposite direction of the CPS building.
Yeah. But surely
I don't think it means very much, but I thought it was interesting.
I hope not. I mean, someone literally saw like walking back towards the CPS building bloodied and muddied. Like,
oh, speaking of that, sorry to be taking over your discussion.
We love you.
Do you think that if he was on camera at the Hoosier Harvest place, do you think that they would have put that in the probable cause if they got the bloody muddy guy on video?
That's
passing by. I mean, you would think that they would have had to, because of the Hoosier Harvest store video. Like, if it's getting cars that are going westbound, then if he's walking westbound, don't you think, unless it just happened to miss him, like say it takes a picture every, 10
I
seconds or something. I don't know. Like,
think it said videos though.
yeah, it did say videos, but like, I don't know. If
Right.
it's like
That's what
activation, like by motion, I would assume a person in the vehicle would activate that just the same.
I know they hold back. I just feel like that's one of those things that would be a very, like, that would be an important part of the timeline that they're putting in the probable cause, and just like one of the car sightings. And also, I would think if they had him on camera there, that they would have found him a lot quicker, because they would have
Mm-hmm.
had some other video, and I assume they would have released that. So that makes me wonder if he came out. It's hard to explain a map that's in my head, but if he would have come out further towards like the trailhead kind of, but out of
Yeah.
the woods, but there's like a house there kind of. I don't know, but I thought that was interesting, or wondered about it. Maybe not interesting.
Yeah, I don't think that he. Okay, so I was trying to figure out, like, okay, from the cemetery to the CPS.
Sorry.
Like, do we know exactly where he was seen by the witness? And I do want to say on the witnesses, I'm pretty sure that I know who all of them are. And I'm pretty sure that there's a lot of people that know who they are. And I'll tell you what, if I see people putting out their names, I'm going to say something every single forking time I see that, because it's because it boils down to one of those, you just want to act like you know things. Well, a lot of people know that. We know the names of them that have been involved in this case, and like armchair whatever since the beginning. Get sick of hearing that too. But you're not cool, you're not smart, you don't know any more than anybody else. Just because you know those names, please don't release them. Like, please have at least that decorum of not doing that.
I agree. I don't think at the time they were minors, but I also think that
But they're
it's
still state
need
witnesses.
to release the witness names. There's a reason they redacted those. And I think that it should be redacted, to tell you the truth. I think they should be protected until trial time. And now the names have been put out there, and I'm just not okay with that. I really am not. I think that it's not taken into consideration the case itself.
Yeah.
And
That's why I wanted to do it like this, where I'm just like reading it without an opinion, and then a little bit
yes,
of a discussion afterwards. But like getting all the way through it, and I've already made this into a playlist, so like the whole playlist will just be more of this, with about 30 minutes tops of discussion time after the reading of it. Some of them will end up being super short, some of them will be really long, but there's going to come a point where public access is going to be pretty sparse moving forward, except for, I'm assuming that anyone that attends the trial will be under that gag order, as far as speaking as to what happened in court each day, if it gets to that place. But I don't know.
Right.
I don't.
Is that a
even
thing that
know if that's
happens?
a thing. I've never seen it, but I've also not. I don't have much knowledge of gag orders, so.
well, and
I don't.
Indiana
Yeah.
still seems to be very secretive. I mean, we've gotten more now than we have in 5.5 years.
Mm-hmm.
And it's still the tip of the iceberg. And I think as it's not I mean, I'm not sure. I'm trying to figure out the thought process. We want justice for the families.
Yeah.
But the families have a big mountain in front of them right now. And they're going to hear the truth. And what I don't want to happen is have people go out there and mock it. You know what I mean?
Mhm.
And
Yeah.
I can understand because they were minors at the time that they were killed. But I also, in reality, I mean, there's other kids this has happened to. It's important to bring awareness on, I mean, these girls that day did everything right.
I know. They
Everything.
did. They went into pairs.
They, yes. And this, innocent until proven guilty.
All right. Last question. Do you each individually answer separately? Do you still think this is connected to Keg?
I
don't
do.
know. I'm going to let Crimezilla go first.
I do. And let me tell you why. I don't think there's a direct connection. In my opinion, this is what I kind of, when I thought about it, I think that the reason it took so long for this to get where it's at is that whole CSAM. I think that somebody had access. BG may have had access to that uploaded file. Is how I'm going to put it with the contact information.
Okay.
But it does seem strange to me that, on the other hand, what would be the point of KK looking up, trying to find out where that gas station was?
Allegedly.
Allegedly.
Yeah.
Let's say allegedly. Thank you, Ivy. So we don't have all the facts in the case. I'm not making a final opinion about this. I want to hear more of the facts on that side of it. Now, they would not put anything in the arrest affidavit about KK because that's totally separate. They just wanted to go through the house and see what they could find. So I'm waiting to make my final opinion, but I'm kind of leaning that it was an indirect association. Let's put it that way. Allegedly.
Okay, Ivy.
So, I guess this hasn't been proven 100%, but I think it's pretty much a given. They found Kagan Klein from very, very, very early in the investigation, likely from one of Libby's devices. Then they had communication with the Anthony Shots account, and that's how they found him. I mean, that's a huge connection. So to me, in that investigation, they had reason to rule him out at the time, which makes me think that he was not involved at the scene. And my gut, for some reason, says that he's not really involved, but at the same time, like, how do you have all these coincidences? And I'm usually not a, coincidences don't exist person. Usually, like, there are all sorts of coincidences that happen all the time that don't mean anything. But there are so many, and the timing is so close. And a lot of the other coincidences we've seen come from, like, online sleuthing, but these come from police. Most of them do. So I'm wondering if maybe the way that the girls got on Richard Allen's radar is because he has some sort of connection with Kagan Klein and CSAM, and somehow that's how he knew about them. I don't know how he would know they would be going out that day, but then maybe that's why they were able to clear Kagan at the time. And then when they circled back, he maybe told them more about, like, this guy I know via the CSAM that you guys have investigated me for, but I don't know who he is. He finally gave them some information. They searched. Maybe they found something in the river, and that pointed to the actual identity like real life identity versus online identity of Richard Allen. Then they link that back with the Richard Allen thing that he put in saying that he was there, and et cetera, et cetera.
Both very good. Like, yeah, they're very reasonable assertions to make.
And he brought his dog and he canoed away, kayaked away down the creek.
Oh my God.
One of those. I don't know.
But remember my relative, you guys. Like, you've
Hey,
known
I'm
about
not-
that for a long time. You know that I'm not just like making that up. Like,
No.
and that's why I feel like it was super irresponsible to leak the interview with Kegan Kline. Because there are other transcript interviews out there of other people that they questioned. Can you imagine that people would be thinking that everybody's involved based on those? It's not logical just to go by that. But I think that has really skewed a lot of things. And even in there, they can lie. Are they going to lie about everything? No, that would be dumb. But he even kind of calls them on it at one point when he says of like, well, I remember talking to her friend. I don't know. Something in my gut, and I know it's not sensible. Like, it is much more sensible to think that he's involved. I keep trying and I just don't. But
maybe he
are
had
like
the
butts,
kayak.
you know.
Maybe he had the kayak. Just one
I
person
bet.
had the kayak that day. Just one.
Well, hey, they did
I
ask
was
my
wrong.
relative if he had any motor whatever you call that for all different types of boats.
Yeah.
And
I was wrong that day.
asked to search them. You were right, like, for thinking that that's a possibility, because why else would the investigator, you know what I'm saying? Like, so if we would have read the one that one had got released publicly, that transcript, everyone would have just automatically assumed that there was a boat involved, you know?
Yeah. Mm-hmm.
Like, that's
Right.
just the way that the cookie crumbles. And that's why something like that should not have ever been released.
Right.
I keep saying I'm going to do it, and I still haven't gone back and done it yet, but I need to go back and look at those transcripts and all of that and figure out what it was that Kagan has either said that he did, or information from the police that was in like either a probable cause or something like that, and not part of them questioning him, and then
Right.
see what's left after you mark out all the stuff.
I would love that. Like, I read that and like found all the places where it's very unclear in there, but anywhere else that's not coming from the murder sheet or like some source that says they have a source you know, like,
maybe we can do that one day. Maybe I'll make a list, go through there and make a list of what was actually said.
hey, Chris.
Like, be 100% confirmed out of all that stuff. Kagan
And
Right.
Mel, can I add one more thing before
Absolutely.
we go?
Yeah.
I just want to put out there that we really, people that are going after the families and going after the alleged, they need to stop. They need to stop. This needed to stop on the Patties and all of them a long time ago. It is one thing to be on a public panel, but make a good choice when you're dealing with these. They lost their loved ones, and anybody that's gone through that, it is unbelievable. Nobody should ever lose a child, ever. And in such a vicious way, these two went.
Mhm.
If you feel you need to, get with a group of people, go in Zoom, and what you say in Zoom stays in Zoom.
Yeah.
And, because you can share, you can plan out, you can do it. a lot of people know that I have a small group. We've been together, and we have all been very honest in that group. We brought different theories. We went for facts. We went down about 100 rabbit holes, if not more.
Yeah, we sure did.
We sure do. And we've been together. It's been almost 2 years, my friend.
I know. We need to have a party.
It's party time. But it is, if you really want to talk about things like that, take it in a closed group and keep it there. And don't believe everything you watch and see, because Google is not always right. So,
yeah,
I agree. I'll add one last thing. It'll be very short, and then I'll go. So we all know, like, statistically, people are, well, I guess when you're younger, especially kids, are more likely killed by their family or somebody they know. So that's always a possibility. But in cases like that, no matter if it's the Delphi case or any other case, at least ask yourself, like, weigh the probability that the family was involved with the damage and the hurt that you will cause the family if they see people saying that they killed their loved one who they potentially had nothing to do with and just lost.
Yeah.
Weigh those with each other before you start making public accusations.
Yeah. Just so that you look smart.
And aren't an asshole.
Yeah, it just shows how dumb you really are, you know? Like, you don't look, you're not cool, you're not special for ooh, look at me, look at me. It's like 2-year-olds do that on the playground, you know? Like,
right.
It's just, but you know, people are assholes, they're immature, they're narcissistic, and you know, they just want to be right, and it's like, it's just disturbing. I don't know, but well, I appreciate you guys coming on and talking to me.
Yeah,
thank you,
nice
Mel.
talking to you. See you guys later.
Chat.
Bye.
All right, bye guys. They're so awesome. That's like that, you know, like there are silver linings and everything, and like I am just so thankful for the people that I've met in this true crime community. Like, just some phenomenal human beings from all different walks of life in all different geographical areas of this big world. And you know, that's just really cool that the different people that you can bring into your life, because the people that we bring in our life teach us something. And I think it's just really special. And yeah, if you want to see some funny different, because I don't make any bones about it, I'm just me, and I can be very serious and I can be very silly, or you know, crass or rude, or you know, just everybody can be everything, and you got to own you. And like if you want to see some fun times, I don't know if it's still up or not, but I was on Sleuth into Witched for a little bit last night. It was pretty funny, pretty fun times. Felt like more we were on like a comedy podcast, and it was cool just to unwind. And I miss doing those with Chaotic. I don't know, she's been MIA lately, so I'm gonna have to call her up and see what's happening. And we need to do me and Aspen and Chaotic soon. But I really appreciate everybody being here tonight, and I hope that this was helpful. I hope that my own bias didn't seep into my tone of voice, and you know, and the way that I read that, and that I just try to keep it just about just that simplicity of when you can see the documents and you can just hear them being read and see them for yourselves all in one place, then you can cut down a lot of the speculation, and then you can do that and, you know, pay that forward. So definitely please share this playlist, because you can share the playlist. You can download the playlist as more get added to it. And, you know, I don't care about getting the information out first. I just care about getting it out in its totality and trying to stick with the factual. So that's why I'm only going to do it like once a month and not every time something comes out. I just can't make videos. You know, you just got to know your role and you got to know your limits. And I work I work a lot of other jobs. I have like right now, currently I have 3 other jobs than this. So that I'm proud of myself for finding the time to put into this, in hopes that it does someday support itself in a way that I can, you know, do this more often, because this is what I love to do, you know? So on that note, you guys, thank you all for being here. And I hope you have a wonderful night, and see you later.